grand jury, so we can just start case with felon.
Okay. I mean, they have 180 days. What if they wait?
Right, and this case was filed in February, so that's August. So we're
So if you
not,
set this for trial, does it kill it upstairs? You know,
well, it would.
It would expedite it.
To dismiss it before the fight.
I mean,
I'm okay with that.
well, it's up to you. You're at 160 now. I'm gonna give you guys another reset, but at that point, you know, it's-
Would it be a 30-day, Your Honor? Or?
Yeah.
Okay.
Yeah.
As long as I can waive my guy's appearance, that's okay with me, because it's hard for him to move around.
What are we doing with the next?
you need to decide what to do, either set it or,
Yeah, I'll set it as soon as possible.
I think that's.
Okay. And then can we just do same bond conditions as the original? Okay.
do they order no contact with it? Is he here now?
Yes, but he's talking noise. Place.
You want no contact on the complainant?
Let me see. Let me look at what they ordered. Hold on. I've got it here for the felony case. It says no contact with Christian.
Over. No contacts over.
Oh,
So.
It's not. It's not. I hope it's not.
That the word.
I was talking about.
So I'm in the felony court. It says no contact.
Okay. So the felon changes, like we should hear Your Honor.
Let me just pull up the felony case, make sure that it doesn't, I'm not 1906. I have 3/1/25. There were bond conditions signed. No contact. He signed it the
He's thinking of the out, most likely.
yeah, he's probably thinking of the MUP is what he's thinking.
Understood.
Yeah, but just explain to him he's not allowed to have contact with this person. We'll mirror the conditions. Since he's here, we'll just have him sign it, or if you want to print out a copy of it and just take it to him, it'll be easier.
Okay.
And then we'll give you the 30 days.
Okay.
What do you want?
Do I need to hear this particular trial date?
No,
Wait, please.
okay. Wait,
Was everything?
Oh, yeah.
as long as we know that he knows and he's,
We are in contact.
I believe,
Okay.
you're an officer of the court, I trust you.
Yes, sir. Thank you.
Richard?
I'm strong. Hey, morning.
I have a quick off docket question. This is for Russell Singleton. We are set for trial May 20th. Last week, felony reset his felony cases to May 20th. Should we keep the same trial date or reset? Keep the same trial date?
I mean, we're
Okay.
set for trial.
Right.
I'm not gonna cave just because they happen to put it on the same.
Okay,
No, I mean, we have our trial date. We're, you
okay,
know, unless he takes something, we're going,
right, okay. So
yeah.
Singleton, Russell Singleton. I think this is Sebastian's case.
Oh, okay.
Yes. Okay, thank you, Judge.
Yeah. Yes.
Morning, Judge. Can I approach?
No.
Yeah. Roaches.
Ready?
Yes, I'm Mr. Roaches.
Top of page 17.
Okay.
Other way around.
The case on?
So what are we doing with this?
It's an arraignment, Judge.
Oh, it's 1,300 days.
Right, Judge. We just reposted bond. You said that name. Roaches, yeah. I don't see it. So I just signed on, Judge, over the
Where's he
weekend.
been for the last 4 years?
¿Dónde has estado los últimos 4 años? ¿Dónde has estado?
En diferentes lugares,
Different places.
porque trabajo
Just,
pintura.
Mr. Roches, you're charged with driving while intoxicated. This case is 1,296 days old. We set cases for trial at 180 days, just to give you a little perspective. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Había uno.
Thank you, Judge.
Es un
An officer is dispatched with traffic hazard and may contact a will witness and another
un
HPD
testigo,
officer
otro oficial de policía.
who found the defendant asleep on the wheel, car turned on the public roadway. There was a bottle of Jose Cuervo in the defendant's pocket and an open bottle of beer in the
Había
view.
una lata abierta.
The defendant had bloodshot eyes, slurred speech, and the odor of an alcoholic beverage. The defendant admitted drinking 5 beers before driving. Serious sobriety tests were conducted and the defendant, law enforcement officers witnessed 6 out of 6 on the HGN, 4 to 8 on the walk and turn, and 0 out of 4 on the one leg stand. The defendant consented to breath that came back at 0.116 and 0.122.
Mr. Roche, I'm going to find that there's sufficient probable cause to go forward with your case. Can you run his NCIC, see what he's been up to and what kind of, if anything, criminal cases he has picked up?
Yes, Judge. Judge, I don't have any cases charged in between this.
Entonces no tiene más casos por medio de este.
So you pull up NCIC for new cases,
No, no
No
case.
más casos.
license?
En licencia de conducir.
He doesn't have one.
Mr. Roche,
Señor Roche,
I want you to understand something, that I take the protection of my public
yo tengo
the utmost serious.
ayuda.
I don't care who you are. I don't care what color you are. I don't care if you're a small farm animal. You endanger my public. It's really not going to go well for you. You do not have a license. You are not allowed to drive. You will be signing an affidavit with me today. This is a promise you're going to make that you're not going to drive.
¿No vas a manejar?
If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? The worst possible thing you can do is drive
Es
in
manejar.
violation of this court order. I'm also ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, I will put you in jail. No more PR bonds. I don't know what your immigration status is, but if you're not in this country with permission, you go to jail and immigration finds you, they will put a detainer on you and you will be stuck in custody until this case is over with. And then you get shipped off to immigration. On your ankle, I'm now going to put a GPS monitor so I know where you are at all times. You will get it on today. Due to the age of your case, I will give you 30 days for you and your lawyer to meet to discuss what you want to do.
Hablan a
At the end of the 30 days, you must accept the plea bargain from the state, or we will set your case for trial. But you get no more time. And I'm going to advise you now that if you ever violate, or if you ever take off on us again, your bond will hit the clouds. Do you understand?
Hasta las nubes, usted no entiende. Yes, está bien.
You will pay for the monitor. And then, is Discovery, what do you have on Discovery? Please, I don't know.
Well, no, yeah.
He's PTI eligible then.
Joe, this case is 1,300 days old. I'm not giving resets. If he's actually going to apply to try to get into the program, he's got to have everything done within the next 2 weeks. You know, I mean, 30 days is the absolute max for him to get everything done.
Is there
Like,
schedule a T-Round
just-
date, I guess.
Yeah, well, I don't know. They're denying more than I've ever seen before. And because he's absconded 4 years, I don't know how that's going to play into it. So I would probably.
I don't think we need a mitigation. It's got to come directly from the DA. Because he's under, it was a .112, is that correct? And then asleep at the wheel.
I don't know. I'm just saying I've seen more denials now than I've ever seen. So before you do that and he has to shell out $300, I would apply first to see if they grant him entry, you know? Discovery complete? Great. So if you can release everything so they have it today. Okay, Mr. Roche, we'll give you 30 days. Be ready. You must appear at the next setting.
All right, let's talk about that. Watching in this docket was like watching someone juggle a hammer and a safety net, laying down sharp warnings, probing backgrounds, but still carving narrow paths for release when the law allowed. The morning opened with Miss Johnson, wanted out of Louisiana for misdemeanor larceny and an older failure to appear on a DWI. Prosecutors pushed for a $10,000 bond, citing the 3-year-old FTA. Fleischer drilled into the problem. Paper tells me another thing, he warned, pointing to her history. Still, he set the bond but gave her one clear chance, turn herself in to Louisiana within 2 weeks. He spelled it out with his trademark bluntness. Don't wait for the last day. Don't blame car trouble or even abduction by aliens. If she failed, he'd revoke and hold her until Louisiana came to get her. Later, the docket turned to out-of-county holds like Michelle Strawnic, stuck on Lee County charges. Fleischer admitted it was unusual. Harris County holds people for 10 days without creating a local case file, so there was nothing to attach a bond to. He weighed whether to set bond anyway, but ultimately reminded counsel that this was a sheriff's office matter tied to the demanding county, not something his court could force. His tone was pragmatic. He wanted to help, but the law tied his hands. Finally came Stephen Davis, back again after multiple missed court dates. His lawyer asked for a PR bond, citing bipolar and schizophrenia diagnoses and a plan to get him into Harris Center. Fleischer didn't sugarcoat it. Davis had been given a general order bond, missed arraignment, rearrested, then granted a PR bond again, only to miss court once more. This is what happens when you don't show up, he told him. The judge's skepticism was clear. Bond is a chance, not a guarantee, but he still listened to the mental health plan before deciding. It was a mix of accountability and reluctant mercy. What tied it together was Fleischer's style. He doesn't mince words, not going to do this repeatedly. Stuck Like Chuck or Abducted by Aliens all made appearances, but beneath the color is consistency. Defendants get one chance, maybe two, but if history shows they won't comply, the door slams shut. Watching him, you see a judge who balances sharp humor with sharper lines. Play games, and you'll sit. Show effort, and you might still walk a tightrope to freedom. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.